Hi, everyone. Hi. Hi. Thank you all so much for coming by. My name is Daniel Feruzin. I'm one of the founders of the West Side Bar Association, and I am so happy to be here right now. We started this organization in 2011. I gotta say, this has come a long way from our first event, and we're very happy about that. Before we get the ball rolling, I want to go over a couple of the boring administrative stuff. I promise I'll be quick, and then I'm going to hand the podium over to Lou Shapiro, who's going to introduce the speakers. First and foremost, ladies and gentlemen, I want to take a moment, and he doesn't know that I'm about to do this. I want to take a moment to thank Mr. Shapiro. He took over the criminal division of the West Side Bar Association, and his events have been nothing short of epic. From the Making a Murderer MCLE, which we had 650 people in attendance at the W Hotel, all the way to where we are today. A lot of this stuff would not have been possible without Mr. Lou Shapiro. So thank you, Lou. I appreciate that. If I could please ask the people in the back, if y'all don't mind just closing those doors, it's a little loud. Thank you, sir. I appreciate that. So a couple of things. We have a little bit more time than usual today, but I'm still going to move very quickly, and I'm just going to get through the administrative stuff. Can I get a show of hands? How many attorneys are in the audience? Wow, no kidding. How many non-attorneys are in the audience? Fantastic. And I got to be honest with you guys, that's our goal. We want to put the clients in the same room as the attorneys because I don't know about you guys, but all the attorneys who I ask how they made their success, they did it by networking not just with other attorneys, but networking with their potential clients. As a result of that, there's a room here with a lot of organic, synergistic networking can take place, and I hope it does. Once the MCLE is over, we're all going to go downstairs. You can have a drink at the bar downstairs, and we can continue on with the mingling and all that. Now, one thing I do have to say, especially for the non-lawyers, please bear in mind there's going to be stuff talked about during this event. Nothing that we say here should be construed as legal advice. People who are watching from home, same thing goes. If you have a legal question, please ask either someone on the panel, ask one of the attorneys in the audience, retain someone, etc., etc. Don't take any legal action based on what you're hearing today. With that said, I'm going to go ahead and put Lou on. Thanks, guys.
Okay, thank you everyone for being here tonight. You're going to hear from some really smart people in a few moments. And I'm up here just to introduce them because I don't want to take up the time. We're here to hear everyone to my left, not me. So just to get started on it, to my left here, we have fresh off the plane, Joshua Drayton. He is a former aide to State Senator Leader Kevin DeLeon. Based out of Sacramento, he now serves as the Deputy Director of the California Cannabis Industry Association. The association is a leading force in the growth and health of California's cannabis industry. It was formed to unite the cannabis industry in California and to allow it to speak with one voice at the state and local levels. Josh is on the floor. He is the voice of everybody here when it comes to cannabis. So we're really honored to have you fly in here to talk to us, and most of all, talk to us about how he was instrumental in getting Prop 64 passed, as we know, which passed just recently by the voters in California in January 2017. Then we have to his left, Sahar Ayin Sazazian. How was that? All right, first time, okay, well, thank you. All right, you'll correct me later. I won't try that in Farsi though, so I'm not even gonna. She is a former associate of Glazer Weil, and she still picked up my phone call. UC San Diego undergrad, Loyola Law School grad, and she is currently the Director of Regulatory and Governmental Affairs at PayQuick. Finally, she is simply scary smart, which you will soon find out. To her left is Alexa Steinberg of Manzuri Law. On their website, she is quickly becoming one of LA's premier medical marijuana attorneys, so that must be true. Actually, it is true. She went to UC Davis and then Southwestern Law. Started out in family law, did that for a few years, but then she got tired of the whiny phone calls. Go figure. So she found cannabis law to be much more therapeutic. So they proudly just produced a publication called Legal Weed. So you can order it. It'll be on Amazon, or you can speak to Alexa directly about it. $70. What's unique to their firm and their practice is, when you see a lot of the attorney stuff that gets sent out for marketing materials, it's like, hire me, for whatever, silly reason. But they actually send out substantive materials. And that was one of the reasons what drew my attention to bringing them to this panel as well. Then to her left, we have the great Allison Margolin here, one of the leading attorneys in criminal defense and cannabis regulatory law in California, Columbia undergrad, Harvard law grad. Yeah, she's still paying off those loans. She's been recognized by her peers as a super lawyer rising star 7 times, including this year. I've had the pleasure of personally working with Allison on cases in her apartment with pizza and all 4 cats and the fish tank. Hope all is well there, Allison. And to her left, finally, John Garza. He is a very well-respected, reputable LA City attorney. He heads up all the marijuana drug DUI cases. I've been working with him ever since I was a public defender. We go back about 10 years now. So he's got great credibility in the field. He will not be giving out his business card, though, just don't expect that. Finally, yes, want to thank Dan Feruzin again, who you just heard with. He is the lifeblood of this system. And also want to, please, if you can, during the break, speak to the sponsors. They're here. We're eating sushi because of them. That's basically what it comes down to. And finally, want to thank Catherine Tang there, a lady in white. She was very instrumental in getting sponsorships here and helping us market the event so that everyone knew to be here tonight. We thank you for your support as a 3L. Thank you. Let's get this party started.
So good evening, I'm Josh Drayton. I am the Deputy Director of the California Cannabis Industry Association. We currently represent about 300 plus cannabis businesses and individuals throughout the state of California. We started about 4 years ago. In this last year, and actually since MMRSA was passed through, currently MCRSA, our membership has doubled. In the last year, our membership has almost tripled. So cannabis is definitely making a wave throughout the state of California. I'm going to touch briefly on MCRSA, the Medical Cannabis Regulation and Safety Act, as well as Prop 64, also known as the Adult Use of Marijuana Act, and kind of how those coincide with one another, how they are parallel to one another, and the reconciliation that we're looking at the state level this year. But to give you a little background about myself, Lou is correct. For the last 5 years, I worked for the state Senate. I worked for the last 2 pro tems of the Senate, strictly on the political side. So I didn't have a whole lot to do with the Capitol building. My skill set is much more in running campaigns, voter persuasion, using data to influence voters based on fact as opposed to alternative facts, which we've all learned a lot about this last year. Over my last 5 years working in Sacramento and working at the Capitol, I started to realize how much had already been decided by the time it gets to the state level. And I started to feel like I needed to get back to my grassroots efforts. I lived in Humboldt County for about 12 years. I grew up in Ohio, in Midwestern Ohio, went to Miami University, a very conservative university, and then once I graduated, decided I needed a change, so I moved to Humboldt. It was quite a change. My very sheltered life in Ohio, I did not deal with cannabis growers. I did not deal with a community that had an economic base that was based in cannabis funds, and it really changed my outlook in a positive way. I think, like many others, I was dealing with 50 to 100 years of negative propaganda about a plant that was unfounded and just, again, based in alternative facts. So, coming to Sacramento, working for the Senate Democrats, we started to get to a place where we started to look at regulations for medical cannabis. Medical cannabis, which was lawfully put through in the state legislature in 1996, and that was under Prop 215. So between 1996 and 2015, Nothing was done. There were efforts made to regulate and create a regulatory structure for medical cannabis, but that really never got off the ground. It was still something that people did not want to touch. Legislators were afraid to touch this, lobbyists, just the whole way through. So as we started to get this passed through, and we started to see cities and counties banning left and right, that is when I decided to leave the Senate Democrats and jump into cannabis. We had not enough people with a political background, with a regulatory background, that were willing to take this on, and I kind of felt like I had nothing else to lose. I care about this. I believe in medical research. I believe in science. I believe in data. And I believe that regulations help public safety and public health. So I made that jump. So in the time that I've been with CCIA, we did pass through the Medical Cannabis Regulatory and Safety Act. This was passed through the State Assembly and the State Senate in a package of bills. There were 3 bills that were packaged together, which initially were called the Medical Marijuana Regulation and Safety Act, later changed to Medical Cannabis Regulation and Safety Act. We always stress changing the name marijuana to cannabis because marijuana is the derogatory name that was given to the plant to give it a Latino name so that it made it easier for white America to be against it. So yes, we continually fight to change anything named marijuana to cannabis. The Los Angeles Office of Marijuana Management yesterday changed to the Office of Cannabis Management. So everyone is kind of catching on to this. 2015, this did pass through. The regulations were not written. This was just the directive to create the regulations for strictly medical cannabis use to create a state regulatory structure. So on Tuesday of this last week, the regulations dropped at the state capitol. We will not see those regulations until Tuesday of next week. But this should be the guiding force as to what we'll be seeing as far as regulations for medical and recreational use. So it's been a very big year. Come November, we passed Proposition 64, which allows for recreational use. The big difference in the 2 of these, I'm going to go back and forth, so at any point if you have questions, just shoot up a hand and I'm more than happy to answer that. But the medical regulations were created within the state legislature. So senators and assembly members created these regulations. Those regulations are easily adjustable because they were created within the state. Proposition 64 was passed through by the voters. Anytime a voter initiative is passed through, to amend those, the conditions of that initiative is going to take a 2/3 supermajority vote back to the voters. So what we're dealing with right now are a regulatory structure that deals with medical and a regulatory structure that deals with recreational. So at the state level, we're dealing with what we're calling reconciliation between these two. There are some major differences in these 2 different policies. One, the medical regulations does require a mandated third-party distributor for cannabis. This has been very controversial at the state level because it is felt that the cannabis industry is going to take on an unfair burden of employing a third-party distributor for their products for testing, as well as to get out to the market. That distribution channel is roughly going to take about 30% of sales. The Prop 64 Adult Use of Marijuana Act does not require a mandated third-party distribution system. They allow for vertical integration. If you are a brick and mortar dispensary, you can hold multiple license types. You can be a dispensary, you can do delivery, you can do distribution. The only thing you cannot do is testing. Testing licensing is the only license type that cannot take on any other license. And that's a stopgap. You know, they're trying to do their best to do a stopgap at that point to say, these are not necessarily stakeholders. These are the folks that are going to test your product make sure it is safe, and get it back out to the market. So that's something that we're going to be dealing with heavily in Sacramento this upcoming year. The governor put out his budget trailer bill, and it heavily favors Prop 64. And again, one of those big arguments, the Teamsters support mandated distribution and a third-party mandated distribution. They have vowed to fight that the whole way through. Whereas most of the other associations do believe in independent distribution. And so that's something we're going to be dealing with heavily. The other point that we're going to be dealing with is the size of cultivation. So Prop 64 allows for a maximum of 22,000 square feet of cultivation, and that is for the next 5 years only. So for 5 years, 22,000 square feet is the cap of cultivation under Prop 64. At 5 years, it will go back to the legislature to decide if that cap, which is meant to keep out monopolies from large corporations of coming in, big tobacco, big alcohol, the whole way through. Is that still good for the market? Are we meeting the demands of the people? But at 5 years, they'll have to go back and review that and decide, do they go ahead and lift that? Or do they go ahead and continue that as we move forward? Whereas under MCRSA, the medical regulations, under the 10A license type, you're able to have up to 4 acres of cultivation. 4 acres of cultivation equals about 176,000 square feet. It's a big gap. It is a really big gap. So these are some of the things that we're going to be dealing with at the state level this year. We have 44 bills that are touching cannabis in some capacity at the state level. I kind of want to bring it back down to LA again because I realize you guys are all local, and for the past year I've bounced between Sacramento, Los Angeles, Oakland, just the whole way through. And one thing I do recognize is in Northern California, we've been a little bit more comfortable talking to our legislators, talking to our regulators about cannabis because it's such a huge part of the economy and they can't ignore it. And cannabis community members have come forward much easier over the years. When I first started coming down to Southern California, I recognized, it was really tough for anyone involved in the cannabis industry to step forward because of the incredible police state down here. Measure D that went through in LA City capped the amount of not even licenses or permits. Pretty much these folks received, limited immunity. 140 shops were able to open, brick and mortar dispensaries, under limited immunity. Not that they couldn't be raided at any point, not that they had a license and were fully permitted, but they could just somewhat in the gray area operate. LA County, unincorporated area, has been in a full ban for 5 years at least. As we've seen, anytime you go into a full ban, you really increase the illicit market amazingly. And as we've seen in LA County, let's be honest, the cartel grows are just incredible the whole way through. So what I have found is that education is the key the whole way through. Educating constituents on new marijuana laws, on new cannabis laws, educating regulators on what real cannabis businesses and industries look like. I continually take regulators on tours of regulated facilities, unlicensed facilities, so they have a better understanding of what we're really dealing with. We took 30 regulators from LA County to Palm Springs Safe Access and to Candescent so they could see, what a real cultivation site looked like, to see what a real brick and mortar dispensary looked like. On May 25th, we bring them up to Oakland to show them, what manufacturing and extraction look like. So they can see outdoor cultivation, so they can see testing labs. This is a new industry for everyone. The law language that you guys speak, I don't speak. The cannabis language that I speak, you don't speak. And we all need to be working together the whole way through because we've never seen such a boom in an industry that is so unknown. As we're creating regulations, as we are trying to figure out the best practices and the best paths forward, we still have no idea. So we count on working together with everyone and educating each other on fact, on data, on realities so that we can create those best policies the whole way through. I'll be here to answer any questions afterwards, but thank you for your time.
Hi, everyone. I'm Alexis Steinberg, and I work with Mansouri Law. I have a team of 2 other women, Maytal Mansouri and Michelle Mabugat, who's so nicely sitting in the front row. And we do criminal defense and cannabis business law. We started in criminal defense ever since the firm was born in '08. And we realized that there were a lot of people coming to us whose grows had been raided, dispensaries had been shut down, and they were really ill-advised as to how to run their business properly, which really meant for a very poor defense. And I didn't have the tools I needed in my toolbox really to present that defense when it came time to do so. And so our firm shifted a little bit, and we took what we understood in the criminal defense capacity, and we moved it to a proactive stance where now we are helping businesses incorporate, be compliant with the state laws, with the local laws, and really advise them how to not only to be compliant, but to have a defense should they be forced to present one in a court of law. So that's sort of where I come from in this stance. So I know Josh talked a lot about the MCRSA and Prop 64, but I want to bring it back just a little and create a little bit more of a foundation for what I'm going to discuss with you. So in '96 was when medical marijuana was made lawful in California. Since then, we had the Medical Marijuana Program Act and the Attorney General Guidelines, and what those did was they kind of solidified the Compassionate Use Act, the CUA, and the Attorney General Guidelines kind of gave us a guideline as to how these businesses should be run. And it wasn't law, but it was so persuasive that we used it as law, but it was simply a guideline, and ironically, or maybe not so ironically, it was written by Jerry Brown, who was our Attorney General at the time and is now our governor. And so we can kind of see how he's really pushing marijuana law in California, which is great. He's a phenomenal advocate. So since then, since the Attorney General Guidelines of 2008, there really has been nothing in California to create an infrastructure for these businesses to actually come together and be lawful and compliant. So the MCRSA was a huge turn for the marijuana industry when it passed. And what it did was created a comprehensive licensing system. But in actuality, it created a bureau in Sacramento to actually put forth these requirements and regulations. And so it took them about a year to set up the infrastructure of this bureau, 2016 to 2017. Lori Ajax, who we took from ABC, she's now heading this bureau. And now this year is the year, I like to call it the year of agency. So we have all the different agencies coming together to create the requirements and the regulations of these licensing. So what the regulations are going to look like, what the applications are going to look like, the requirements, all of that sort of stuff is being created right now. The Department of Agriculture is putting pen to paper, the Department of Pesticide, to really create a comprehensive understanding of what the regulations of the marijuana industry in California are going to be. And then we anticipate, although I believe it's a little eager, a January 2018 date of when applications will become available for medical marijuana. And then we had Prop 64 that passed this last November, which then made it lawful for anyone 21 and over to possess either 8 grams of concentrate, an ounce of marijuana, or 6 plants. And really what that did is everybody thought that, it was completely legal, but we're still really waiting for Prop 64 to roll out. So at midnight of the election, it was lawful for anybody without a recommendation to be in possession of an ounce of marijuana. However, this didn't apply to businesses just quite yet because there's no licensing yet. We're still sort of in that same cycle that the MCRSA has created for medical licensing for businesses. So the dispensaries that are open, if they have a Prop 64 compliant sign, that means nothing, just so that you know. It's a big question that I get. There is no Prop 64 compliant dispensaries in Los Angeles because there is no licensing for that. They all still need to be medical. So if you want to be in possession of cannabis as a recreational user, you're either growing it yourself or you're gifted it by a patient who's going to the dispensary for you. But you can't pay for it, so find good friends that'll just give it to you. So the big thing, and I know Josh also touched upon this, there were really big discrepancies between these two different laws, and it created for a regulatory nightmare. And so the governor now has his trailer bill in Sacramento, which is going to essentially marry the regulations. They took Prop 64 and kind of inserted some MCRSA language in there and kind of made it so that the regulation wasn't so chaotic. And so what we learned that the MCRSA was in regulations, what we learned Prop 64 was maybe vastly different by the end of the summer once the trailer bill goes through. It's attached to the California budget, so they'll be voting on it this summer. But one of the major caveats under the MCRSA was in order to get, and Josh also touched on this, in order to get a state license from California, you were required to have a local permit first. That meant whatever city you were operating in had to have an ordinance that gave you a business permit, essentially, to operate within their city limits. This proved very, very difficult for Los Angeles. So I'll give you a little bit of a history about LA. We have Prop D and pre-ICO shops, and that's something that people kind of throw around. I've had a lot of people come into my office and say, I have a pre-ICO license, I'm licensed in Los Angeles. Licenses don't exist in LA. So what pre-ICO and Prop D did was way back in 2007, there were way too many dispensaries popping up all over LA. And the city determined that they didn't want them sprinkled like Starbucks everywhere, so they were gonna put a cap into play. And they went to all these dispensaries and they asked them to register with the city. And at that point, a lot of these dispensaries were like, you're not gonna trick me into that. I'm gonna end up on a list and then I'm gonna get shut down. And so there were about 200 at that point, give or take, that registered with the city of LA to be on this list. And it took the city from 2007 until 2013 to put this cap into play. And so they passed what's called the Interim Control Ordinance. And the dispensaries that registered became known as the Pre-Interim Control Ordinance dispensaries, pre-ICO. What that gave them was a limited immunity. So it wasn't a license or a permit to operate. They could still be raided, they could still be shut down, still be arrested, but they had an affirmative defense when they got into court that they were operating in compliance with LA law. But I will tell you that it's almost impossible to be in compliance with LA law and with Prop D. Specifically, there's one section of Prop D that states that if you are a dispensary or a marijuana business in Los Angeles, everything has to be done under one roof. That means you're making your concentrates, you're growing, you're making your edibles. Everything's being done in the same spot. Not only is that not safe, but it's not cost effective. If you want a dispensary, you want to be on Wilshire, you want to be on Ventura Boulevard. Who's going to have acres on Ventura Boulevard or Wilshire to grow, enough for your patients? And so it's just completely, it just doesn't make sense. And so Prop D, we already knew there was a problem with that. But when the MCRSA passed, we determined that really we needed a license. And all of these Prop D dispensaries thought that they were safe and they had a license until our lovely city attorney, Mike Fuhrer, determined that he was going to send a big FU email to all of the pre-ICOs saying, hey, you guys, you thought you had a license, you don't, and you're not eligible for a license at the state level. And so this created a huge uproar in Los Angeles. And I have a lot of clients that are cultivators. And the cultivators sort of got on this train. And we started a group called the Cultivators Alliance, which is now the SoCal Coalition. And we began to lobby Los Angeles for affirmative permitting so that we could be able to go to California once these licenses came out in 2018 and be eligible to apply for those. And so that's sort of what went on and where Measure M came from. And so what Measure M did, which passed a few weeks ago in March, the special election, March M controls LA City, and what it does is it amends Prop D. So Prop D was a voter initiative, and Josh also touched on voter initiatives. If it's a voter initiative, you have to go to the voters to amend. And Prop D was exactly that. And it was very difficult for them to amend it in any way. And so what Measure M did, or Prop M, was it returned the power back to City Council to be able to amend Prop D. And what it also said was, with that power being returned to the City Council, they're going to use that power to create licensing in LA. And so what the City Council is doing now is they are putting pen to paper as to what the city licenses are going to look like. And we're going to look at those later this year, probably September, October, is when permitting will come out in LA City for the industry. And so everybody's very excited about that because it's before the MCRSA and Prop 64 licensing comes out. So everybody will be prepared. So LA is really gearing up for that. Prior to that, under the Attorney General guidelines, which actually still apply because there are no licenses, you have to be a nonprofit entity, is what the Attorney General guideline says. And you have to operate like a collective or a co-op, which are really the same thing. A collective is defined by a dictionary, and a co-op is statutorily defined, and so a lot of people like to be collectives because it gives them more leeway to do what they want. But they're the same thing. And it's really run by the members for the members. So anybody who's ever been to a dispensary, they walk in, they have to sign a membership agreement, become a member, and they have to operate within this closed circuit. And so that's how these businesses have been operating as well. If you want to bring your product to a dispensary that you're growing, you become a member of their dispensary, and somebody from the dispensary can become a member of your collective, your grow, and that keeps the closed-knit, closed circuit of the entities. And so that's sort of how it's been run for the past umpteen years. And when licensing comes into play, one of the biggest changes that we're going to see that everybody's really excited about is that you can be a for-profit entity. So once you have a license, you can change your entity structure from nonprofit to for-profit, and then you've got a license and you can operate that way. There is what's called the sunset clause on the collective defense. So your collective defense is that you're operating as a collective, you're a nonprofit. I like to set them up as nonprofit mutual benefit entities, which kind of inherently explains that it is a collective or a co-op because it's for the mutual benefit of the members. Those are the kind of things that you need to present to have what's called a collective defense, to be in compliance with California law currently. That won't be available once licensing comes into play. There's a bit of a grace period, and then you either have a license or you don't. And that's how the cannabis industry in California, that's where they're moving. One of the biggest things that we're going to see in the industry as it becomes more mainstream is branding. That's a really big issue. In order for these growers to stay relevant, to survive in a licensed environment, you're going to have to brand yourself. And so more and more my clients are coming in, creating brands, going mainstream. It's quite interesting because a few years ago, the clients that I came in were very much marijuana clients in my office. It's whatever your mind defines as a cannabis client. But more and more I am getting corporate men and women, people who want to come into the industry, find it a cash cow. I'm getting Le Cordon Bleu chefs who want to do 5-course edible meals with different strains. I mean, the industry is becoming so sophisticated, and it's nothing like you would ever think that it was. And I'm really excited to see where it goes. And so if you guys have any other questions, I will be around, but I'm going to hand the mic over. Thank you.
I'm short. It is what it is. So, my name is Sahari Nasazian, and as Lou mentioned, I used to litigate. I used to litigate in intellectual property, actually. Had absolutely nothing to do with marijuana. Actually, if you ask anybody that went to high school with me and told them that I work in the cannabis industry now, they would kind of look at you like you've lost your mind. So about a year ago, I began at PayQuick, and my parents were horrified. They looked at me and were like, "So you are now drug dealer?" Okay. They don't think that anymore, luckily. So what PayQuick does is it enables compliance-based state legal electronic commerce throughout the marijuana supply chain. And I'll get into more of what that means later. But first, I'll paint a picture for you. So a lot of the co-ops that you work with, or a lot of the marijuana businesses that you work with, they'll have a grower go in there with pounds and pounds of marijuana stuffed in a bag that they drove down from their grow, and they get there, they deliver it. The girls behind the counter, or the guys behind the counter, start to shuffle cash together, put it in a brown paper bag, and hand it over to the grower. And so the grower does this a few times, makes all their deliveries, and at the end of it all, they have around $150,000 or so, right? Yeah. In their car, which sounds really awesome because, oh my God, I have $150,000 in cash in my car. This is great. No, that's not good at all. That is not good at all. You do not want to be driving with that much cash. Now, compound that with all the deliveries that you're going to be making for a month, for 2 months, for a year. You have a lot of cash sitting on your hands. Same thing goes for dispensaries. Patients come in all day long, buying in cash. And so you have hundreds of thousands, if you're a really, really lucky dispensary, millions of dollars just sitting there. You'll put it in a safe. You will go the El Chapo route and bury it underground. I don't know. But there's only so much that you can do with cash, and it's really, really unsafe because cash invites violence. Criminals know that marijuana businesses are sitting ducks. They're sitting there with a lot of cash, so they'll break in and they'll know that they'll have a nice payday, and a lot of the marijuana businesses really won't go to the police because they're a marijuana business. Why is there so much cash?
Why can't they put it in the bank?
Why is there so much cash and why can't they put it in the bank? So your larger banks, like your Bank of Americas, like your Wells Fargos, like your Chases, they have a federal license, banking license, if you will. They have a federal banking charter. And let's keep in mind, marijuana, no matter how many states begin to legalize it, continues to be a Schedule I substance. Pretty high up there with like heroin and meth and cocaine and all that jazz. So yeah, cocaine is lower. So banks won't touch the money that comes from a marijuana business. And then you have the state chartered banks or the local community banks, which have a state charter, which we'll get into more. But a lot of these banks won't touch marijuana because of the federal issues and because of the reputational issues that go into dealing with marijuana, and because to bank marijuana, it takes a lot of know your customer due diligence. Where does that come from? So on the federal level, The only things that are kind of protecting marijuana are the Cole Memorandum and the FinCEN guidance from 2014. What the Cole Memorandum is it came out originally in 2013, and then the second iteration of it came out in 2014. And it lists 8 guidelines that the federal government looks to, which is making sure that marijuana money doesn't go to the cartels, making sure that marijuana stays out of the hands of children, that it's not grown or consumed on federal land. And what the memorandum says is if a business is complying with their state laws and is making sure that they're not incriminating any of these 8 enforcement priorities, the United States Department of Justice can't use its limited resources to go after these businesses. Keep in mind, this is only a memorandum. Now, last summer in the Ninth Circuit, the memorandum got a little bit more bolstered because of the McIntosh case, where a bunch of defendants that had been raided that weren't implicating any of the 8 enforcement priorities and were following their state's rules were raided. And so they went to the court and said, hey, what are you doing? And the courts actually said, no, Department of Justice, you really can't do that. And then you have the FinCEN guidance from 2014, which say that if you follow these know your customer due diligence rules, or priorities per se, you can actually bank marijuana. Those are very, very in-depth. It takes a lot to actually know your marijuana business. You have to look through their application files. You have to be going through all the money that they're bringing in. You have to be taking in all of that cash. That's a lot of cash that your counting machines are going to be busy all day and night just counting. And on top of that, when you are banking marijuana, you have what are called marijuana SARs. SARs are suspicious activity reports. And for marijuana, you have your marijuana limited, which is just, I got marijuana money. You have your marijuana priority, which is, this kind of looks weird. And then you have your marijuana termination, which is, you have to shut this business down because they are probably laundering money right now. And so to file those and to file the currency or cash transaction reports that go with receiving all that cash is very, very hard. So banks either won't touch it, or if they do, they're going to charge the business an arm and a leg to do that. So that's why it's so hard to get marijuana businesses banked. Now what PayQuick does is that we're first and foremost a compliance company, which means that every single marijuana business that we take on, we make sure that they are properly licensed. We go through their entire license file. We continue to actually go on to the business's own premises and look through to make sure they're following all the rules that they need to be following. And we also work with the banks to bolster everything else that they need, so they kind of feel a little bit more comfortable taking in this money. And so on the B2B side, the way that PayQuick works is, actually Forbes said it best, we're the PayPal of pot. So you are a grower, you make your delivery, and instead of being paid in cash and driving that cash around and, I don't know, burying it, you, with the click of a button, get paid into your PayQuick account. And you're a retailer. Your patients, or soon to be just consumers, come into your dispensary or retailer soon, and they don't have to pay you with cash. You don't have to have an ATM that's standing there on your premises waiting to just be broken into. They pay you with either the loadable card that we have, or how many of you guys know how the Starbucks app works? Yeah, like an app that works just like Starbucks. So there's no cash anywhere. And a big part of what allows us to do all of this is what's called seed to sale traceability. So in many of the states that have allowed recreational and many of the states that are allowing medical even now, seed to sale traceability is a huge, huge part of becoming licensed. What does that mean? It means that from the moment that your plant is viable, your little baby plant, it's tagged and it's barcoded, and that barcode is scanned over and over and over again through every stage of the plant's life until it happily ends up in the belly or the lungs of the consumer. So because of that traceability, states are able to know exactly what's happening with the marijuana throughout its life. They know that it's not being taken into the black market. They know that it's not being diverted across state lines. They know that it's not being sold into the cartels, or the money that they're getting from that isn't being given into the cartels. So we actually work with that, and we make sure what you're doing continues to be kosher, basically. And what I specifically do at PayQuick, or one of the things that I do, because you do a lot of things at a startup, which I didn't know when I left my life as a litigator, but one of the main things that I do is that I work with regulators and with legislators on a local, on a state, and on a federal level to first and foremost educate them about what the marijuana industry looks like now. Because the marijuana industry now is, like Alexa said, it's not what it used to be. It's very highly sophisticated people. The plant has grown an entire microeconomy around itself, where you have the marijuana businesses, you have attorneys whose practices are focused on marijuana, you have engineers who are creating ways to have better grows and make better vapes, you have artists who create beautiful bongs that can also be like a flower pot. You have everything you can imagine. So it's really important for regulators to be educated on the normalization of the marijuana industry. And what I continue to tell them is, as you're writing your rules, you need to make sure that you are taking into account how the money is going to be coming in and out of these businesses. You need to make it so that financial institutions feel comfortable handling this money. You need to make it so that financial institutions can actually do all of the due diligence that they need to do. And when it comes to marijuana businesses themselves, the biggest thing that I tell them is be transparent and be fully honest. The less that you try to hide, the better off you will be. The less you try to hide, the more access you'll have to all of the things that will make you a normal, was that a question?
Yeah. Where's the money? Where is the money held that backs up the electronic indications that you have money, so you could essentially bank back and forth with your clients?
We hold that money.
Hold it at a bank, or?
It's at a bank, yes. It's at an FDIC insured bank. It's not in our backyard.
That's a whole other question.
It's not in our backyard, I promise. So, transparency, yes, that's very important. And another thing that is really, really important for businesses to know is don't fall for schemes that'll get the cash out of your business. If somebody comes to you and tells you, hey, I can run legit credit cards for you, ask them what the MCC code that they're using is. Ask them, how are you running my credit cards? Are you miscoding it so that if I get caught, I'm blacklisted, and if I run a shoe store after this, I still can't get another merchant account? And a really, really biggie is there's a lot of cryptocurrency, like Bitcoin, that's starting to come into the industry as a means of getting the cash out. Do not get involved with cryptocurrency. I cannot stress that enough. Of all the regulators that I've spoken to, of all the legislators that I've spoken to, they do not like cryptocurrency. Cryptocurrency is very difficult to trace. It has a really bad name. It enables money laundering, basically. And that's something that's going to get you much more heavily scrutinized than you really want to be at all, because you are still a cannabis business. So if you guys have any questions, I am more than happy to answer them. Yes.
What about taxes? I would think the federal government would want to get their hot hands into this and tax it.
I think they do collect taxes right now. Yeah, they do. And they actually just passed a packet of bills, one of which, or a couple of which, deal with marijuana taxation, but those aren't really expected to pass, so don't get your hopes up.
Well, I mean, the bottom line is, in one breath, they're preventing you from going to a bank, and in another breath, they want taxes.
Well, you're not prevented from going to a bank. It's very hard for you to access a bank. So prevention and it being very hard are two different things.
I can chime in real quick and let you know that even despite the fact that the Attorney General guidelines require that in California you're a nonprofit entity, because marijuana or cannabis is still federally illegal, you don't qualify for 501c3 tax exemption status. So you're operating like a nonprofit or not-for-profit business, but you're paying taxes like a normal business would. So believe me, they'll take your money.
And on top of that, there's, on top of that, there's also the 280E exemptions, which marijuana businesses don't get to exempt a lot of their business expenses from their taxes because it's still a federally illegal substance. So
I have a couple questions just from Chain, what you said. You said you were FDIC. How is that possible? How are you federally insured?
our banks.
Your banks are.
Yes.
So you're not the bank.
No, we are not the bank.
So you're like an intermediary.
We are. It's exactly what we are. Yeah.
And you can do that with federally insured banks.
We've been doing that in Washington State for about 2 years now. We're going to be coming into California by mid to end of 2017. And
Okay,
Go
so
ahead.
when you mentioned that banking relationship typically takes a lot of time because you have to really deeply go into the business, the banks to make sure that they're, with all the suspicious
SARS.
SARS and everything else. You guys aren't doing that? Are you saying that basically your compliance is going to be this barcode C2 sale?
No.
How are you finding the viability, the kosherness of the entire transaction chain so that you aren't money laundering, say, through Europe?
So what we do is we do really, really thorough compliance checks on all of our clients. Oh, your question was essentially, correct me if I'm wrong, how do we make sure that everything our clients are doing is kosher, essentially?
Exactly.
So what we do is we have ongoing continuous compliance checks on all of our clients. We continue to actually go onto their premises to make sure they're acting in compliance with state and federal law. We continue to look over everything, all of their transactions to make sure that they're complying with state and federal law. And that's how we make sure that everything's kosher. Am I okay to keep answering?
Let me take over from there. I appreciate you guys' enthusiasm for the questions. Let me hop on here because we're going to take our break in a second. We are ahead of schedule, ladies and gentlemen, which means we'll actually have real time for a Q&A at the end. It's always the most difficult thing to get to, but we'll get to it. In the meanwhile, I'm just going to throw something out there that I think our people want to hear. And I'm going to open it to the panel as a whole, including the speakers who haven't spoken yet. In here, are there people here who are looking for transactional attorneys to help them with their marijuana business? Just give me a show of hands. Okay. Are there attorneys here who want to get involved in the transactional business of marijuana? Just a show of hands. Okay, exactly. What I wanted to open to the panel is, and any one of you who wants to chime in, the attorneys that are looking to get into this business and the people who are looking for the attorneys, what should they be doing?
Well, I'm happy to start. First of all, the idea of a transactional marijuana attorney, and I take a conservative approach, is still a violation of federal law. I would not call yourself that if that's what you're interested in. Number one, and it's a really strange thing. This is going to be, I guess, the subject of my speech, but we're in a very weird situation. It still is a federal crime to do marijuana activities. And I do lectures with the U.S. Attorney for the Eastern District on this issue. And there's a very fine line between advising someone on licensing and doing their application. And the things that you would normally associate with transactional work, like doing the application for licensing, doing the incorporations, is still technically a federal crime. Now, not to say that it's generally enforced against attorneys, but there's one particular attorney that I know of who's been indicted and I think just pled to 7 years for his involvement with marijuana businesses. And I only know of that one example. However, I mean, like, one person getting 7 years is enough for me to give you that advice. And that's actually a district that's like not a very harsh district, the Eastern District. But I mean, I'm sure that my colleagues here have a different opinion. But, you know, I'll discuss that whole line of thought further, but that's at least my thought. It's a very strange thing. It's a kind of quasi-advising.
Well, I'll jump in here, because as we represent, over 300 businesses, and we're talking about Weed Maps, Berkeley Patients Group, Harborside, the whole way through, what I am finding a plague is, and this may be a little bit harsh, I find that attorneys are jumping in not knowing that these laws are changing every single day. Interpretation of these laws is changing every single day. You need to have your foot in Sacramento or have someone in Sacramento every single day, and you need to have somebody in your city council meetings and your county supervisorial meetings every single meeting time. Because they change, as soon as the winds change, they change. And you have to be able to instruct your clients appropriately, and I'm just finding so many folks jumping in that don't quite know the law, that are giving people very vague direction. So know it, and it is, like I said, there are 44 bills at the state level right now that touch cannabis. Any one of those could pass at any point. And if your attorney is not on top of that, if your client is like totally putting all their trust in you to get them through this process and you're guiding them down the wrong path, I mean, come on. It's tough. It's a heavy lift right now. This is really changing. I know we all felt like Prop 64 was going to pass through, everything's fine, we're good. No, the political activity is non-stop. So get politically active, advise your clients to get politically active. They need to be advising you, and you need to be advising them.
Fantastic.
I agree. Can I piggyback?
Please,
real quick?
absolutely.
I totally agree with what Josh is saying, and we experienced it firsthand with the Cultivators Alliance and SoCal Coalition. And I advise my clients all the time, what city do you want to operate in? Go know your city council, go know your neighborhood council, get involved. This book that we wrote, the first edition we wrote almost 2 years ago, and this is our 4th edition in 2 years, because that's how quickly the laws change. And this was just printed in March, and it's already out of date because it doesn't talk about the trailer bill.
It'll all be out of date in the next couple months with reconciliation.
Yes.
So.
I mean, if the trailer bill passes, what we know of the MCRSA, what we know of the AUMA, Prop 64, will kind of be, for the most part, irrelevant because they'll have completely new, although it will take bits and pieces. So yes, if you want to be involved in it on the legal side or as a business owner, your number one key goal here and your number one thing is get educated, stay educated, and be on top of it. That's why my office, that's 95% of what we do. And
Wow.
we can't avoid that because it has to be our daily lives. We have to sit on Google Alert, knowing everything that goes on. And we have parties that we work with directly in Sacramento that keep us up to date on Sacramento law too.
Wow, and I thought labor law was changing real fast. Apparently nothing like cannabis law. So what we're going to do is we have 2 more presenters, and once those 2 presenters are done, if we have time, we'll do a Q&A. Once that's done, we have 1 or 2 more raffles, more stuff coming your way, and then we're going to take everyone downstairs, and we're going to have the mixer down there. All right, guys? So with that, I'm going to pass the torch to the next speaker.
Yeah.
Hi, everyone. So I was originally going to do criminal developments for Prop 64, but I think we should kind of shake it up a little because we've heard a lot about marijuana regulations. So basically, I guess what I'm going to talk about is first some advice for people who want to become, marijuana lawyers. And I know that's a lot of people in the group. And why is that? Because the rest of the economy is not that great except for marijuana. And that's kind of a reality that kind of, I think, overwhelms even this whole issue of regulations and kind of why we're in this position, that we are starting to have regulations. And I guess people are interested because they see it as a burgeoning business. So I kind of want to talk to you, I guess, a little about my experience kind of in the trenches of the war against marijuana, which we're just coming out of, actually, surprisingly, in the courts, and what you need to look out for as a practitioner, considering that it's still a violation of federal law to be involved with marijuana activities. So you heard a little bit about the beginnings of marijuana law in California. It started in 1996 with the Compassionate Use Act. And in the beginning, we basically had laws that immunized certain types of conduct from criminal sanctions. In the beginning, there was an initiative that said you can grow your own marijuana, or you can grow as a caregiver for others. But that was a very limited concept, which means like you could grow marijuana for someone who had an extreme medical condition where you had to actually do caregiving for that person. And that kind of prohibited the idea of these mainstream dispensary type stores that's more convenient, obviously. So because there was a need for dispensaries, the legislature actually passed the first marijuana sales legislation, not just recently, but in 2004. And that was also this kind of immunity type of clause. And it basically said certain conduct, again, was immunized, including marijuana sales, marijuana transportation, any other kind of marijuana conduct would be immunized if qualified patients collectively associated to cultivate marijuana. Now, it also had this other clause in the law that says this must be done on a non-for-profit basis. Now, you've heard that this kind of requires a nonprofit. Well, that's actually not really true. When you litigate these criminal cases, but I'm going to tell you two kinds of advice. One is like a criminal defense advice, and then one is like a proactive advice when you're dealing with people who are trying to comply. But as a criminal defense attorney, the law until January 1st, 2019 is still that patients who collectively associate, as long as they're doing it in a non-for-profit basis, may have immunities. And what does that mean in practice? Well, I mean, it can mean like you have a client, this is like an example of a case I actually went to trial on and we ultimately won. A guy with a bunch of weed on his body and in his car, there's a search warrant executed. He has text messages to friends that have, some of whom have recommendations, saying like, you know, can I get a bud? Can I get an eighth? Okay, so that kind of scenario, you would think like, how do you have a defense? But actually what's awesome is because of the way that the medical marijuana law was written, and this is Health and Safety Code 11362.775, it's still there, is very vague. Even though the AG guidelines say you have to have a corporation, when you look at the CalCrim, which is the jury instructions for this that we finally got in 2015, it says that it has to be non-for-profit. When you have like a few people you're selling to, that doesn't mean you necessarily have to have a non-for-profit corporation. What it means is that you have to somehow frame your activity into marijuana sales that result in a person who's the operator having a salary that's based on overhead costs and operating expenses. But on a criminal level, it's been really fabulous. We've been able to basically get people off of felonies until Prop 64 for many years based on the vagueness of the law. Now, what's strange is that the reason that the law was weird and vague and only immunized conduct is because we have this federal law called the Controlled Substances Act that says that regulating marijuana is actually illegal. Okay, this is very strange because now we know in the context of the country we have many states that are now regulating marijuana. Well, although that is the law of the land, the Obama administration put out this memo that was discussed that said that basically if people have robust legalization systems, then the feds will generally stay away. So this is very strange as a lawyer because, you know, first of all, a violation of federal law makes it less likely you're going to be prosecuted. That's very odd. But that is what that was what the Cole memo said. Now, did that memo prevent the DEA from further doing anything? Not really. And did it prevent U.S. attorneys from prosecuting people? No. But for the last 2 years, we've had this thing called the Warbacher-Farr Amendment in Congress that says that the DEA can't use funds to medical marijuana states. Now, does that stop the DEA? Well, what we have to understand is that this is like bureaucratic politics. It's way beyond what's the right thing to do. Should marijuana be legalized? We've had since 1968 huge bureaucracy and law enforcement that's been set up to deal with marijuana offenses, other drug offenses. Half the federal prisons are still drug offenses. So even though we have this memo and we have this amendment, the DEA and U.S. attorneys can still file cases. You guys heard a little bit about the U.S. versus McIntosh case, and that is a good case from the Ninth Circuit that says if you're in strict compliance with California law, you have the right to an evidentiary hearing in federal court. Now that sounds awesome. Of course, no one ever has successfully had this evidentiary hearing yet, so it sounds great. But the reality is, and I don't want to be like scaring people because there's been very few federal prosecutions over the last few years. However, the reality is that you'd be, or your client could be in a position where they're fighting a federal case that's 10 years to life, which is usually what federal cases are. And okay, so they have a medical marijuana defense possibly, which we don't even know what that would mean. And what it says in the federal court is that strict compliance is what you have a defense for. But then we're going to get into the issues. I'm kind of going to discuss like what are the issues in the future. Well, what does it mean to be strictly complying? Well, the district attorneys in California from 2004 through even like currently, they think you can't even sell marijuana in California. Their position is that all sales are illegal. And the federal government has also taken that DA position when they're litigating these post-McIntosh cases. They're saying, well, you will have to, they're taking the positions that the DAs took for many years litigating these cases that there really aren't sales allowed, that you have to be a caregiver. So when we think about, yeah, there's a federal defense, but when you get into federal court and you have US attorneys arguing whether you have a defense, they're gonna take a very narrow view of things. So it's in that context that we now have these massive changes in criminal law relating to marijuana and this regulatory system. And the basic changes in criminal law from Prop 64 has been that all marijuana offenses in the state are now misdemeanors, unless the marijuana is being distributed out of state, and or the person has a super strike, which is like a murder or arson, something very serious case, or they have a 290 registration. And if you have any of those categories, then it's still a wobbler, meaning a felony or a misdemeanor. But this is obviously great news for like the random marijuana grower or transporter. That is doing it even, in this weird gray zone that many of the speakers have already talked about, that now it's a misdemeanor offense versus a felony. Another great change that's happened is that the smell of marijuana is no longer probable cause. So that's part of Prop 64. That started November 8th of 2016. And it's very exciting. And that's, I think, a way that I think the government will, not have a chance to get into as many people's lives. And obviously, the number of prosecutions of marijuana has gone greatly down. And I'm sure, as Jonathan will tell you, the prosecutions mostly center on city attorney cases. And actually, once Mike Fuhrer started as the city attorney in LA, what actually happened that was kind of a good thing was that the DA's office stopped prosecuting felony marijuana cases for the most part. Even this is before Prop 64. And they took it down to the city attorney level where it was a misdemeanor case. Now, as a practitioner, though, just kind of like little practitioner tips. So let's say you get a misdemeanor marijuana case, and you're like, oh, this is awesome, it's a misdemeanor, it's not even a felony. Well, it's not that awesome as a practitioner. Why is it not that awesome? Well, when you practice criminal law, you'll know that if you do a felony case, you can get off the case after the prelim is over. Okay, so let's say you get a certain retainer. This is like big practice tip. You get a certain retainer for a felony case, it's good through preliminary hearing. Well, when you're on a misdemeanor case, which you think, oh, big deal, misdemeanor case. Well, I'm sure Jonathan will tell you, they have their own bureaucracy. The many city attorneys, they're very happy to try a misdemeanor case. And then as an attorney, if you don't do your retainer correctly and get enough money up front, then you'll be stuck on some misdemeanor case that could become as complicated as a previous marijuana felony case. So just a little practice tip. The other issue when you're going from the area of criminal law to regulatory laws, I kind of touched upon this earlier, is that because marijuana is still, and the activity is still a federal offense, there are certain things that put you in the gray zone. And there are things that all your competitors, or many of your competitors, are gonna do, which is kind of part of the angst of practicing in this area. And one thing is incorporation of corporations, some simple things like a mutual benefit corporation, California one, recommended by Jerry Brown, is still, if you are becoming the incorporator as an attorney, it is like you being involved in a federal crime. Now, the chance of being prosecuted, I'm sure, is low, but you can still get prosecuted. When I just gave a recent lecture with the US attorney, he characterized that as 68 on a 65. So take that for what it's worth. The same thing with these licensing applications. People want you to do this general transactional work, like do my license for me, because who wants to fill out forms? And of course, that's what in other businesses the lawyer can do. And it's at least our position that you can advise someone on the law that's applicable to licensing, but you can't actually sit there and do the form for them, because that really makes you then being involved in marijuana activity. The one lawyer that I know of who's been indicted for this, we studied his case kind of extensively in our office to make sure we don't do what he did. But basically he was involved with his clients, basically he introduced clients that were tomato growers, and he suggested they go into marijuana growing, which sounds kind of crazy, but it's not really that crazy when you think about regular business lawyers dealing with marijuana as if it was just a regular commodity. He also shared profits, which is something people seem to think is no big deal, but I mean, one meaning of nonprofit definitely is you cannot have a percent profits. That's like definite, okay? So anybody who's kind of taking these regular transactional principles yet and saying, oh, let's do a percent of this, oh, I'm gonna make this percentage off this, that's like totally illegal under state law. And because of the strict compliance under federal law will put you in a bad position. Okay, 5 minutes. Okay. So I'll just spend maybe the last 5 minutes on some little practice pointers and things about the law that I learned through my years of having to litigate these marijuana cases before we had this great Prop 64 that pretty much eliminated marijuana arrests. So some little tips, trial tips that I learned along the way. Number one, the value of doing written motions in limine for any trial. And the marijuana trials forced us to do that because from 2004 through 2015, there were no CalCrim instructions. So we had to do briefs on, asking for special instructions, which is also something I learned from litigating these marijuana cases. Don't be afraid to ask for special instructions that you make up. But the most important thing is to do it in a motion in limine, on the day of, turn it in obviously the day of trial. And you'll put yourself way ahead of usually the other side. We'll see what Jonathan says. That was one thing I learned. Another thing I learned was the value of having your client testify. A lot of times we're afraid of clients testifying in criminal cases. And I've had all sorts of experiences. One time I had someone with a prior manslaughter testify, and my partner, who's a fabulous lawyer, he opened the door, though, unfortunately, that time to that conviction coming out, and we still got an acquittal. But that also brings me to another point to make sure as part of your motion in limine, you're litigating things like prior convictions. Like in that case, manslaughter would be overly prejudicial, not probative of anything. Some little practice pointers. Other tips, pretrial motion work obviously taught us to do quite a bit of it, and some motions that we did along the way, motions to traverse search warrants. Right now, if you get a marijuana case, the smell of marijuana isn't probable cause, so I haven't even seen any search warrants since November for marijuana businesses other than people violating zoning laws. So that's something that's interesting and new and good. And anybody who does work regarding immigration cases, Prop 64 has major good consequences, because something that people don't realize is, I'll give you like a 2-minute rundown, if that's okay. So cultivation of 6 plants is no longer an offense at all. Let's say you have a client who has an old marijuana felony cultivation, and the general thought is, oh, now it's a misdemeanor because cultivation of over 6 plants is a misdemeanor. Well, in LA County, as most of you guys would know, the pleas usually don't have factual bases. So that what that means, if you have, let's say, an old person who is like deportable for a marijuana cultivation offense, there is no factual basis plea, you should ask for that case to be dismissed as opposed to just a misdemeanor reduction, because the case law from Prop 47 and other areas says that you only can look at the record of conviction to determine what the person did. It's not like you go behind the police reports and all this. So it could have a major impact on immigration if we kind of spread the word more about how extensive this Prop 64 can be. And it applies to any old marijuana conviction for sales, possession for sale, cultivation. Maintaining a place is something that's been left out of the statute, but you can still try to argue that that should be reduced to a misdemeanor. So the state basically has, in large part decriminalized marijuana. That's a great thing. But because there still is this federal bureaucracy and the DEA out there, that actually, if this appropriations rider doesn't get continued, then any activity that we do now can be enforceable if it's within the statute of limitations. So that's just also something to note about Macintosh. That let's say that next week they don't continue the appropriations rider, then any conduct that we do, like even within the statute of limitations, can be prosecuted when there's no rider. So it's just something to be very aware of when you're, dealing with marijuana cases. I would say that whenever you have a conversation with a potential new client, you should treat them as if they're basically a DEA agent. I mean, I know a lot of people might think I'm paranoid, but that's the way you should handle it. You should always tell someone in the call, and in your retainer agreement, marijuana activity is against federal law, but I can tell you how you can comply with the state and the local law. And that's kind of the way that we choose to do it. So I'm happy to take any questions afterward, and we'll hear from one of my opponents.
I wish I could say that they saved the best for last, but it's never a good idea to end a panel with a prosecutor. I'm going to try to go through this really quickly. Going to talk about kind of who I am and what I do. Try to get you guys out early so you can get to your intoxicants and the free sushi. So my name is Jonathan Garza. I'm a Deputy City Attorney of the City of Los Angeles. Basically, I'm a DUI drug vertical prosecutor. What that means is any drug DUI that happens in the Valley basically ends up on my desk. I'm not really involved at the policy level, but what I'm going to talk about is kind of the drug trends that I'm seeing and kind of what's going on in the trenches, both in the court as well as at DUI checkpoints. So my caseload is made up entirely of drug DUIs. That includes not only marijuana, which is about 80% of my caseload, but also includes illicit drugs, heroin, methamphetamine, even prescription drugs. I get a lot of cases where people are high off their prescription meds and they're plowing into vehicles. So that's what I do. You heard a lot about Prop 64 and kind of what it did and how it decriminalized marijuana. What I want to talk about is kind of the misconceptions of Prop 64. So you know that one, it's legal to possess as well as to smoke marijuana, but it's still illegal to drive under the influence of marijuana. It's also illegal to smoke in public, and a lot of people I feel don't understand that. I see that wasn't meant to be a joke. So I see a lot of defense attorneys in the crowd. Actually, a few guys I actually have open cases with. And I hate to give out all this good stuff to you guys. I see you guys he has pen and paper over here, he's writing down everything I say. But for a lot of the defense attorneys that have these cases, if anybody who's ever gotten a DUI case, it's very cookie cutter. It's very boilerplate, right? It's the same thing. It's officer has probable cause to stop somebody. They contact the individual. They smell alcohol or they smell weed, and they ask the person to get out of the car, and they're asked to do field sobriety tests. And it's funny because they always ask, "Sir, have you been drinking?" And with alcohol DUIs, what's their common response? Yes. Yes, officer, I've had 2 beers, right? I liked how all you guys said that. With marijuana DUIs, it's the opposite. It's actually great. People who smoke weed love to talk about smoking weed. A typical police report basically reads like this, where a person gets stopped. "Sir, have you been smoking weed? It smells like weed in here." "Oh yeah, officer, I've been smoking weed, yeah." And when did you last smoke? He said, "Well, I just finished a joint right now while I was driving." And it's "Sir, it's illegal to to get high and drive." He's like, "Oh, officer, I'm high. I know I've been smoking Kush all day, and I'm good. But you know what? It's okay because I have a recommendation." And it's funny because they think that having a recommendation is basically a license to get high and drive, but it's not. I often ask the police officers that I work with to get a copy of their recommendation, because it says, and it's usually underlined, it says, "You cannot operate heavy machinery or drive while using marijuana." So that's a common misconception that I have, and I just wanted to clear up for you guys that are taking your intoxicants and driving. I asked Lou to put into a packet was kind of the elements of a drug DUI. I'm not sure if it got to you guys, but basically, in order for the state to prove that someone is guilty of a drug DUI, I have to prove a few things. One, that a person actually drove. Number 2, that the person's under influence of a drug. And basically, there's a definition in the CalCrim, it's CalCrim 2110, where it says someone is under influence of if their physical or mental abilities are impaired. And on the face, it looks like a really easy kind of burden to pass, right? Basically, drive under the influence of a drug, and either the physical or mental capacity is impaired. But and I'll talk about this later. It's a really tough case. It's a really tough case for us to prove. In my office, for alcohol DUIs, We have a successful conviction rate of like 96% when it comes to DUIs, and that's LADA's, that's the city attorney's office. But with these cases, I think I'm probably like 40, 50%. We're losing these cases in trial a lot, and again, I'll discuss later, but it's, these are tough cases to prove for us. And another thing too, there's a lot of counties in the state of California that don't even prosecute these cases. I was at a high-level meeting, and there was somebody from a county up north, and they said they don't even file against these cases unless there's weed in the car, unless there's traffic collision or someone's dead. They're not going to file this case. Unfortunately, LA County does prosecute. Orange County, actually Orange County is probably the best at these drug DUIs. They're at about a 90% conviction rate, so they're really good at it. So for you guys driving to Orange County, watch out. As part of my job too, I also file these cases. Every Monday, I get to my office, there's a stack of filings, probably about this high, and basically LAPD, the CHP, and the Sheriff's Department drop off people who are arrested for suspected marijuana or drug DUIs in general. And every once in a while, I file these cases and I also reject a lot of them. And often I get a call from an officer who's like, hey, I dropped off a case and you rejected it. Why? And so I always do trainings with officers as well, and they come up to me afterwards, hey, you didn't file my case. Why? So I always like to talk about when I get a file, what I'm looking at, when I'm evaluating a case, what do I want to see? What's the difference between a case that I'm going to file and a case that I'm not going to file? So number one, I talked about the elements of a drug DUI. I want to see that the police report is actually going to make, I'm actually be able to prove each element of this case. Last week I had a case where a LAPD officer came upon, I think it was 4 18-year-olds that were smoking weed in a car. And they were in a parked car to park. And so, the driver got out of the car. He admitted that he was smoking, admitted that he was high. He did terribly on his field sobriety tests. But, I didn't file that case. And why not? Because there was no driving. How can I prove driving if they're parked at a park? So a few other things I'm looking at, does the defendant's performance on field sobriety tests. I told you people who smoke weed love to admit that they smoke weed and that they're high, and did they admit it? Is there a DRE present? A DRE is a drug recognition expert. These are specially trained officers that basically are in the field, and all they do is they're experts in the detection and the symptomology of drugs. And these are highly trained officers. They go through a really rigorous training class, and these are specialists in the field. And a lot of times, if there's a DRE, it's going to be a solid case for me. A big thing too does the report document objective signs of impairment? Basically, every officer has kind of a cheat sheet of the kind of symptoms you expect to see with someone who is suspected or impaired with drugs, specifically marijuana. Usually, there's a few signs that they're looking for. You usually see lack of convergence, elevated heart rate, elevated pulse rate, body and eyelid tremors, reddening of the eyes, memory problems, impaired perceptions, field sobriety tests, bad driving. And these are all things that I'm looking for. These are kind of the main ones. And again, it's for people who are in the practice. The term that you guys love to hear, it's the totality of the circumstances, right? It's always right. It's always about the totality. So I kind of alluded that these cases are really tough to prove, and why is that? And the big part is that there's no correlation with drugs. What that means is that with someone, everybody knows that if you're drinking alcohol, right, at a 0.08, you're impaired. Everybody knows the 0.08 rule. With drugs, there's no 0.08. There's no scientific basis, no scientific evidence that shows that someone's impaired at a certain number. You hear a lot about Washington and Colorado, and you hear about the 5 nanogram rule, right? Everybody knows about this? So that's a number that's made up. There's no basis that proves that someone is impaired. When I'm doing a jury trial, I usually tell my jurors, it doesn't matter if someone has 5 nanograms or 500 nanograms. It doesn't matter, because you cannot prove impairment based on the number. And again, because there's no correlation, there's no 0.08, I think jurors really want to see that. They want to see a .08, and it's tough for us to prove without it. Also, I think that there's been a kind of a cultural shift towards marijuana. I think public perception has really changed on this. My very first jury trial, I asked my jurors during voir dire, who has a recommendation or knows someone that's real close to them that has a recommendation. And 9 of the 12 people in the box raised their hand. Right? My first thought is like, I'm gonna lose this trial. But the thing that struck me the most, it wasn't Cheech and Chong, right? It wasn't the kid with the weed shirt or the weed hat. It was Joe Blow professional. It was Susie Homemaker. It was conservative granny, and I was shocked, and I was able to hang that case, and that was a moral victory for me. But I think that there's definitely a shift towards marijuana. It's becoming more acceptable. Another thing too that's a big issue with these cases is that our labs just aren't prepared to handle these cases. I talked to someone from a lab in a county up north, and they said they don't even test for marijuana. They just don't have the capacity, so that's why they don't file those cases. Even with other drugs, I have cases all the time where someone is impaired with mushrooms or spice. People know what spice is, right? Spice, basically it's a synthetic marijuana. It's supposed to be like marijuana, but it's more has a more hallucinogen effect. Our lab can't even test for this. The other day, I rejected a case because there was a girl who was clearly hallucinating off mushrooms. She hit 4 parked cars. When she got out of the car, she started stripping for the officers, and her labs came back negative, because our labs they don't test for this. So, so the labs, it's a big issue. Since I'm short on time, I'm just going to talk about, so what is law enforcement kind of doing to combat drug driving? And this is it's not only marijuana, but it's also drugs in general. I think in the past year, I've been to about 15 meetings with, the alphabet soup, DMV, LAPD, CHP, OTS, NHTSA, basically every government agency that deals with traffic safety and law enforcement. And I'm seeing kind of a collaboration that I've never seen before. I think since about maybe 7 or 8 months ago, we started to kind of get together, kind of work towards kind of getting in front of this. And we're trying to push for more kind of officer training. We're pushing for a bigger budget for more DREs in the field. And also we're going to start making cadets learn about drug DUIs and how to detect these symptoms. It's about public safety. So we're pushing towards trying to make the roads safer. Another fun thing that I actually that I found interesting is that pretty soon NHTSA is going to roll out public service announcements. Right? You guys, when you're driving the freeway, you see the buzz driving is drunk driving. You're going to start seeing some of that. I know in Colorado they have a PSA that says, drive high, get a DUI. So I think you'll see something catchy like that. Hopefully, I think probably in the next 3 to 6 months. So I know we're working on that right now. Hopefully it gets out there. Another thing too is we're going to the grade schools and high schools, talking to kids about the dangers of smoking and driving, and it's about putting public safety.
Just a quick question. Obviously, with alcohol or prescription drugs or CNSs, there's clear impairment that affects how you drive. I used to work at the city attorney's office. I did a marijuana trial, and it went very poorly because,
Yeah.
very similar to your experience. And at the time, when crime lab scientists wanted to testify that smoking marijuana even affected driving the way alcohol or a CNS would. So has there been any new science along that route since 2012?
Well, the next point that I was going to make is that we're starting to publish more studies. NHTSA is putting money behind doing more case studies. We're getting a lot of information from Colorado and Washington. We're getting a lot of data, and we're trying to track data. So I think we're seeing in the next maybe 2 or 3 years, you'll see a lot more more studies that are geared towards kind of field sobriety tests and the sensitivity to those cases. In terms of our crime lab, we've been pushing them hard to get out and testify in favor of that marijuana actually impairs your ability to drive. Because 2 years ago they wouldn't testify that marijuana impairs your ability because there was no science to do that because marijuana affects people differently.
Could you address rumors about there being a weed breathalyzer or a swab testing, and how hard do you think it's going to be up for you guys to get that stuff admissible under FRI?
Again, so that's actually my next point. Thank you. So the other thing we're also doing is since 2014, 2015, the city attorney has been part of a pilot program where they have what's called it's oral fluid testing, and essentially what it is, it's almost like a large Q-tip that someone puts in their mouth, and they rub it around their oral cavity, and they put it into a machine that basically tells the officer that that drugs are detected. So it's a roadside pass machine that we've been testing. In LA, we've been using the Draeger 5000. Other counties have been testing what's called the Larry DDS2, and this is a program that's in LA County, Orange County, Bakersfield, Fullerton. There was a case, I think, out of Santa Barbara where we had that issue, and then actually it surpassed the Cali FRI. So it's something that we've been kind of slowly pushing forward. It just got passed, and I think there was a bill that is being pushed forward. I think it's AB 1356 and AB 6 that are they're trying to put that in motion and become a part of this. So and lastly, just legislation that that's being pushed. So in the last few years, legislators have tried to make laws to kind of get in front of this. A few years ago, there was a law, I think it was like 2013, that they wanted a zero tolerance. So if you had any nanograms in your system, you're going to be prosecuted for DUI. That never made it out of committee. There was a 2 nanogram, per se limit that also died. Right now, there's a AB 2740, which is a 5 nanogram per se limit. And it's not being supported by a lot of the law enforcement agencies because we think that 5 nanogram per se limit doesn't really work. But so it's probably going to die in committee as well.
Is the absorption theory going to be applicable in the same way? Do you guys have that stuff going on for alcohol? Does it usually translate over to marijuana? That bell curve?
Marijuana affects people differently. There's no bell-shaped curve. Basically, it's you ingest it, you hit a peak, and then it dissipates rapidly in your system. So it's a big issue. So, okay, thank you.
We're gonna have a Q&A at the end.
So first and foremost, a special thank you to our panel. They took time out of their days to come by here today, and we really appreciate it. Ladies and gentlemen, thank you to the WBA board, Brian Clark, Lou Shapiro, all the sponsors. Thank you all so much for coming.